Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. We are set for 3 different cases this afternoon, 2 of them by oral argument. The third case, Roger Blasdell versus Lynnhaven, Inc., is hereby submitted without oral argument. Our first oral argument today is Green versus North Central Iowa Regional Solid Waste. It looks like the parties are ready. Is that correct? And you are Mr. Clark. You may proceed.
May it please the court. Opposing counsel. My name is Ryan Clark, and I represent the employer and insurance carrier in this matter, North Central Iowa Regional Solid Waste Agency, and IMWCA. This case involves an injury that goes back some ways, almost 11 years ago. And as you might expect, because of that, it's got a relatively lengthy and complex procedural history. Naturally, for the best recitation of my arguments and my client's position, I refer you to the briefs in the matter, which I think will closely parody the final agency decision in the current matter. Rather than go through my outline, with my time today, what I'd like to do is cut to what I think is the crux of the matter. I would submit that this case was over, should have been deemed over, upon the district court's first judicial review decision. That happened back in May 1st, 2017. By that time, all justiciable issues had either been stipulated to, litigated, or resolved. The law of the case was as follows: that claimant sustained an injury that arose out of and in the course of her employment on April 30th, 2012. That was not disputed. Defendant stipulated to a compensable injury. That same injury resulted in a mild, if any, injury or injuries that resolved quickly. As a result, claimant failed to meet her burden of proving the injury proximately caused any permanent disability. Number 3, the law of the case was that claimant was not entitled to temporary disability benefits or missed time from work beyond those which had been voluntarily paid prior to the hearing in the case. And number 4, that claimant was not entitled to receive any ongoing or future medical care at the direction or expense of the employer and insurance carrier. That's it. The case is over at that point. That fact in granting my client's motion for summary judgment. It followed the law as concerns review reopening proceedings and when summary judgment is proper. Yes, ma'am.
Call House, we recognized review reopening is proper when a temporary disability later develops into a permanent disability. Why does that language not cover the situation here?
This case, the temporary disability did not morph into a permanent disability.
Based on the facts that existed at the time, what about subsequent? My understanding of review reopening is that it is to address things that happen after a prior decision is made.
Issues were ripe for adjudication and had already been decided. In this case, it was the finding that claimant was entitled to temporary disability, not beyond what had already been paid. And at that point, the injury was deemed to have resolved. And while claimant had the opportunity to do so, she was unable to prove at any point in the proceedings that that same injury resulted in permanent disability. That case was litigated and done with. Excuse me, that issue was litigated and done with.
Isn't that kind of a question that we have here, of whether in fact it did get worse? I thought that that's sort of what we were here fighting about, is after that happened in the years that went on, it got worse. And it's the reopening hearing
What has happened in this case, however, is that review reopening is being treated as though it's an appeal, another appeal on the merits. And what's worse than that, it's being treated as though, forget the prior decision that this injury did not cause, proximate cause, did not cause industrial disability. Let's skip that. Let's assume that it did, and now let's talk about extent. You did not get to the issue of extent if the injury did not proximately cause a permanent injury or disability. That was fully litigated.
What about Bayer Glass? Doesn't Bayer Glass say that you can get an award of medical benefits only and then later reopen it and seek industrial disability?
It says yes. I don't dispute that.
Different circumstances, because it sounds like that's kind of the situation here, right?
The issue of was not yet ripe for adjudication. It had not been adjudicated yet. Whether or not claimant in Bayer Glass was entitled to temporary disability benefits, first of all, and permanent disability benefits, second of all, had not even been discussed yet. It had not been litigated. The parties had not offered any evidence on those issues. This case is different. All the issues were ripe for adjudication.
Or if there's different evidence, and not different evidence relating to her condition at the time of the original decision, but evidence of her condition now that shows it's different.
Relevant. If that were the case, there are plenty of my cases I've lost that I'd like to submit evidence from my own doctors down the road and say, hey, look, things have changed.
Statute that said you could, like this one appears to, that would be okay.
Under the right circumstances. Review reopening, what the cases teach us is that review reopening requires proof that the disability is proximately caused by the injury.
If she were, for example, this claimant suffered, I believe, a kind of upper neck, shoulder injury, is that right? Something like that. Let's assume that through odd circumstances, it worsened into an injury that caused her to lose vision. It ended up being a nerve injury. It's your contention then, if she were to lose her sight, that issue was adjudicated in the prior decision and she can't reopen this file to seek permanent disability benefits.
If there had been an award or a finding that the injury was proximately caused, that the disability or some disability was proximately caused by the injury, that is something that review reopening is meant to address. It's meant to address future developments. It is not meant to address issues that have already been adjudicated. It's review reopening exists to re-examine where it's appropriate, whether something has happened that indicates a diminishment.
In the prior case, let's say she sought total disability benefits and she was awarded 1% body as a whole. Is it your contention then in that case you would say, well, in the prior case this was adjudicated, it was litigated, and there's no finding that this caused 100% disability. And what's the difference between that case and this case?
The 1% disability, there must have been a finding that the injury proximately caused permanent disability. May not be much right now, it's 1%. That's why we have review reopening is unique to work comp. That's for sure. And it is meant to address that very situation you're talking about.
Let me see if I understand your position. So your view is if, in this case, instead of a hearing, the employer, insurer, carrier, whatever, had just voluntarily paid the medical benefits, the temporary disability, and there was no hearing, but then later on, the employee sought review reopening, that would be okay under Bayer Glass, right?
The settlement, but it could be.
If there had been a hearing and there was a 1% finding, and the employee later sought review reopening, if they had the right evidence, that would be okay too, right? So your view is limited to the situation where there's an actual hearing and there's a finding of no causation, right? Is that?
The parties have had an opportunity to litigate each and every issue. There were if you go, and I assume you have, if you go through the record, the arbitration decision and the appeal decision has a detailed analysis of all the evidence in this case.
I don't see Buyer Glass as turning on the fact that there wasn't a hearing. It just says you can reopen an award, right?
Reopen an award, but in order for this to proceed, Ms. Green would necessarily have to relitigate the issue of whether her injury approximately caused disability. That's why we have res judicata. It provides parties with some finality.
Review reopening by itself, just like you pointed out a moment ago, is sort of contrary to the notion of, it's sort of an exception to res judicata, right?
Exception to res judicata.
If you know, somebody else had been responsible for this accident that injured Ms. Green, and she sued that, you know, third party, and then there was, and she got an award of damages, she wouldn't be able to go 3 years later and say, hey, my injuries are more severe than I thought. I'd like to go back and ask the jury for some more money. So it is an exception to res judicata, isn't it?
Principle that's unique to work comp that you wouldn't find in civil law, but the cases teach us that even in review reopening proceedings, Kohlhaas, Polestar that's on this issue, Kohlhaas says that res judicata applies to review reopening proceedings.
And that's going to be a question for Mr. Schnurr, because why the normally very careful Justice Hecht mentioned that.
Cases talk about res judicata applying in the context of the claimant can't provide additional or different evidence to prove the injury, the state of her injury at the time of the hearing, but what she's seeking is compensation for her condition now, which is a different point in time. And at least as I read the cases and the treatises, that is kind of a statutory exception, maybe to res judicata, but also to finality of judgments, right? That she's essentially getting a different disability rating at a different point in time once there's been a determination that the injury arises out of her employment. That seems very different to me.
Correct. Injury I'm not correct with everything you said, sorry, but correct that there was a stipulated injury, that the stipulated injury resulted in the need for medical treatment and that it resulted in the need for time off of work. We voluntarily paid those things before hearing ever happened. We disputed specifically whether that very same injury resulted or approximately caused any permanent disability. That was disputed, and then it was found, as I haven't gotten to it yet, but at every stage was found, even in the district court on the first appeal judicial review decision, the district court found that there's substantial evidence to support the commissioner's finding that the injury did not result in disability.
How could the court have determined whether it had worsened if the time hadn't yet come for her to put on evidence of its worsening?
On the current motion for summary judgment, the reason why we're here, and I don't mean to sound crass, that is not relevant. The issue is that issue was tried. The claimant had her, Ms. Green had her own experts with regard to nature of injury, causation to disability, extent of disability. She had a vocational expert come testify about what effect this injury had on her life. That was all litigated. And they don't get to extent issues because the law of the case is that this particular injury did not proximately cause any disability. It's already been litigated. She's lost. Review reopening requires a worker to prove proximate cause before review reopening. So in this case, what claimant is attempting to do is say, well, forget about that. Let's assume I did suffer permanent disability as a result of that. Tell me how much it's worth now. You don't get to do that. That's not what review reopening is for. That's why we have res judicata as a longstanding.
Authorities from other states to see what they've done with respect to their similar workers' compensation statutes. For example, I just want to know if you're familiar with a Kentucky case that was decided 4 months ago that addressed this exact question. Lakshmi Hospitality Group versus Jimenez. Their statute is almost identical to ours. and they say this is kind of the exact fact pattern where you should have review reopening. And
And I would, with all humility, I'm not familiar with that case. That's the answer to your question, I'm sorry.
Stronger res judicata case if she had lost originally and found that there was no work-related injury, but they found she did suffer a temporary injury, and I'm having trouble understanding why, if her condition later worsened, she couldn't do the review reopening.
About that scenario, I was of the opinion that I could not think of a stronger case where res judicata would apply than this one, and where she isn't entitled to any permanent disability. Yes, I think if it had been found that this never arose out of it in the course of employment, the first step, yes.
So the distinction is that there might have been a work injury, but it didn't cause a permanent disability. It's the causation to the permanent disability that's the...
And not just that it might have caused an injury, we stipulated that it did.
Right, and does it need to... So was there also a finding that it did not cause even a temporary disability?
It's found that it caused a temporary disability for a period of time, and in this case, the injury happened in April of 2012. The disability that was volunteered by my clients ran through August. The law of the case is that that is all she was entitled to because this was a temporary, minor, at worst injury that resolved by that time. That's it. I see my time is up.
Thank you. Mr. Schnurr?
Sorry, Jerry.
May it please the court. I'm Jerry Schnurr. I represent Olivia Green. We are here to ask the court to affirm the Court of Appeals decision, which found that summary judgment was not appropriate in this case, and that Ms. Green is entitled to file her claim for review reopening. And there is a question of substantial fact as to whether there has been a change in her condition since the original decision. Iowa is unique, and Iowa's not unique, but the work comp system is different. As the court appears to see, we have statutory framework for workers' compensation. And the legislature has determined that some decisions are subject to being reviewed and that they aren't final. The employer and the employee both have a right to review these decisions. If Mr. Clark's client loses a case and there's a permanent total disability, let's say Ms. Green was found to be permanently totally disabled. 10 years down the road, 20 years down the road, technology has improved. She's been able to find employment earning $50,000 a year. He can come in and through his client and review that case, even though at the hearing, the issue of the extent of disability has been litigated. The defendant has put on medical evidence that she's not permanently totally disabled. They've put on vocational evidence that she's not permanently totally disabled. But they can come back under the statute and review that case to determine.
The language from our dear friend Justice Hecht in Kohlhaas, it's sort of dicta, but he says, review reopening is not the place to litigate causation issues that were determined in the initial award. So what do we take that to mean?
So I want to read a little bit more from Kohlhaas. Excuse me, technology. So what he goes on to say is if there's an award or an agreement for settlement, and it goes back to Beyer, the award or the agreement establishes employee-employee relationship and that the injury was caused by work, then you're entitled to review reopening if benefits under Chapter 85 are awarded. That's what the statute provides. So he talks about res judicata and Kohlhaas. So for example, if we are relying on substantially the same evidence that we relied upon in the original proceeding to come in and say, Here's the facts. We disagree with the outcome in the original decision. The original decision is the baseline. We have to come in with new facts and new evidence to show that there's been a change in the client's condition, in the claimant's condition, whether physically change in condition or a change in economic circumstances. It could be that, as Coalhouse recognizes, could be a temporary becomes permanent, a scheduled injury becomes an industrial injury, a physical injury becomes a psychological injury.
Oh, go ahead.
So I think I agree with your reading of Coalhouse and and maybe how that language was meant in the context of that case. On this record, what is the evidence that her condition worsened? And I went through the medical records of Dr. Naumann and the other things that are in the record, and it seems like that the only thing the doctor can say is, talk to is her condition now, but he doesn't have, or she, I'm not sure, she doesn't have evidence of the claimant's condition at the time this was actually litigated. So there's really not comparative evidence from what I can see in the record.
We have to go at what the decision was. The decision was there was no permanent impairment and no permanent disability. So that's where we start. So now we have treatment that occurred after that decision that shows she's increased migraine headaches that are affecting her. She's got treatment for from the pain doctor. The physical therapist shows there's a loss of motion and a loss of strength in the injured part of the body. The condition of that injury has changed. And so it...
Doctor has to have knowledge of the condition at the time. The rating is just a legal conclusion and a way to assess the benefit.
An impairment rating is a medical opinion as to loss of function. The disability is a legal opinion as to loss of earning capacity. And so the finding of the commissioner that there was no impairment and no disability, they're two separate findings by the commissioner at the time of the original hearing. The impairment is a medical opinion on loss of function, physical function. And there's an AMA guide that put out to evaluate the impairment. And that was litigated. But it was also litigated in Coalhouse, and it was also litigated in Bear Paint and Glass. And in Coalhouse, the injury was to the claimant's foot, a scheduled member, a scheduled injury. And on workers' comp, you have the claimant has a schedule of certain injuries.
Her evidence at the original hearing about the level of her impairment.
Evidence also, as Mr. Clark said, we submitted evidence of impairment and loss of function, medical evidence, opinion evidence.
That you were asking for at that time. I mean, it seems, I mean, you did present some evidence of an impairment rating, and now there's going to be new evidence, that you contend at least. So I'm not sure that the impairment evidence is necessarily as important as the comparative evidence from a doctor with knowledge.
And that's one of the things Coalhouse says. And so what we have done, now understand we filed our petition for review reopening. Within 90 days, the motion for summary judgment was filed. And so in response, we submitted medical records that we had to show that there is at least a question of fact that we ought to be able to litigate as to whether her condition has changed from no impairment, no disability, to some impairment, some disability. And that's what we're here about. Under the statute, we ought to be able to do that, under Bear Glass and under Coalhouse. In fact, the argument of the employer is essentially to overrule Coalhouse. Coalhouse stands for many things, but one of the main things Coalhouse stands for is the overrule of the acuity case. The acuity case and the rule in acuity says the only way you get review reopening is if that change in circumstances wasn't contemplated by the parties at the time of the original decision, kind of like a divorce. And so that was the rule. Coalhouse says that's no longer the rule. Even if the parties contemplate a change in condition or contemplate that there's a permanency, you can have review reopened if you have evidence of a change in condition.
That talks about relitigating, and you two were both too polite to correct me, but the chief pointed out it was Justice Strite that wrote Coalhouse, not Justice Heck. Anyway, the language about relitigating, that refers to, what you're saying is that means you can't bring in the same evidence. You can relitigate the issue in the sense that you can
And of disability. And that's what the Bear Paint case says. Bear Paint says specifically that an award of medical benefits only is sufficient to allow review reopening. And in that case, the court noted that in the original decision, they did not award any temporary or permanent benefits because the claimant didn't have any time off work, didn't have sufficient time off work to trigger those. And so that tells me they litigated that issue initially. And the Bear court said medical benefits are enough, and then the extent is based on the evidence of the evidence that's submitted on review reopening.
Sure about something you just said. You said you can relitigate the issue. I think
I should have been more clear. It's a different issue.
litigating the claimant's injury at a particular point in time of the hearing, you're not relitigating it. You're determining her injury at a later date. Okay.
That's one of the reasons that Coalhouse does what it does, is so because we have this framework in workers' compensation that allows review reopening, they want them to make this decision based on what the facts are at the time, okay, and not speculate about what might happen in the future as far as disability is concerned, or earning capacity, or physical changes.
This is not a case of a temporary disability developing into a permanent disability. Do you agree with that?
That's one of the claims we're making, is that this is a case where there was temporary disability that was found.
Clarify that, because I think that's what he seemed to say too, is that there was a finding of you agree that there was a finding there was no permanent disability.
There was a finding of no permanent disability, not that there was a finding of some permanent disability caused by something else, whether it's another health condition, a pre-existing condition, another accident, or anything like that. And so I don't agree with that characterization of it. I agree that this is a finding of no disability. There was a finding that there was an injury caused by work. And I think that's one of the issues of res judicata. That's enough. And
At least even a temporary disability. And that's what we get from Bear.
a finding of an injury arising out of in the course of employment, and some benefits under Chapter 85. And as Bear Paint and Glass says, medical benefits are enough. And then you can come back.
Award.
Award or an agreement for settlement.
It could be just an award of temporary benefits, medical benefits.
And in Bear Glass, they litigated that, and medical were awarded, and he had spondylolisthesis, the claimant did in that case, and they came back seeking temporary and permanent. One of the concerns raised by the court, because it's not just an award, it's an agreement also, an agreement for settlement, because the agreement for settlement requires an arising out of employer-employee relationship and an injury caused by work. So one of the concerns of the court in Bear Glass was that an employee gets injured, they rush in, they pay medical bills, they get an agreement for settlement that says, this is it, we agree to settle, and it's over. And as Mr. Clark said, in that case, if the condition gets worse 6 months later, there's no review reopening. You agreed to a settlement, and that's done. And so if we now, what Coalhouse says, we don't have to, even if you consider or future conditions were within contemplation of the parties or the decision maker, you're still entitled to review reopening. What he wants to say is, what the employer wants to say, and the argument here is that, nope, the only way you get review reopening is if you didn't submit the issue of permanency initially. And in Cole House, the injury was to the foot. They argued initially that the knee, hip, and back were involved and that industrial disability should apply. The agreement was entered, just the foot, a scheduled injury, and they submitted a medical record at that time that said the knee, hip, and back is not caused by the injury, therefore not applicable. Review reopening was allowed in Cole House to consider the knee, hip, and back and industrial disability after the agreement for settlement.
Talk about causation, res judicata applying to causation in Cole House. That's that this injury caused something that resulted in an award as opposed to it was caused by something completely unrelated to the work injury?
Injury at work. So what's the cause of the injury? And then review.
Actually cause a disability, it just has to cause an injury.
That results in an award of some benefits under Chapter 85, which would include medical or temporary benefits. And so
Legislature's just allowing for the possibility a worker may get worse, and then they can come back and recover for the worsening.
it's different than tort because in the grand bargain that resulted in workers' compensation, the workers gave up a right to a jury trial. They gave up a right to seek pain and suffering, future and physical and mental pain and suffering, lost consortium, all sorts of damages. And in return, they're only, the employer's liability is restricted. The medical care is controlled by the employer as long as they admit it. And so the recovery is loss of earning capacity. It's based on number of weeks and average weekly earnings, about 2/3 of what your wages were at the time. And so part of that is the legislature said the employer and the employee have the right to come before the commissioner to review cases if there's a change in circumstances, whether it's physical or economic. And I see my time is up. Thank you very much.
Sure. Mr. Clark, I'm going to ask you a question before you even get there. Can you address the very first example that Mr. Schnurr gave about how if the shoe was on the other foot, you could come in and ask for a break on behalf of the employer?
I cannot do that. I'm not allowed to submit new evidence when the case has been fully submitted, has been fully litigated. I can't do that. Now, if it had been determined that, let's say there was an award of industrial disability, the court went ahead and found, or the agency found that this injury resulted in permanent disability. She's not, the individual is not working. I'm going to assign 60% industrial disability. In that situation, if I come back and show that the patient, the individual is now working, that they're earning substantially similar, in that situation, yes, I can file for review reopening. That assumes that there was causation to disability in the first place. That's not this case. Mr. Schnurr, Ms. Green misconstrues the argument contained in our brief. It was done so again today. What we're arguing, a couple other things too, before I forget. It was the law of the case that we're not responsible for any future medical care. And again, why? Because the injury had resolved. This medical care and this new evidence is done on Ms. Green's own part. It's nothing my clients were ordered to provide. It's nothing my clients paid for. She's generating her own evidence to say, let's leapfrog causation, and now I'm worse. It's not just an extent.
To the argument that the causation is only that it caused an injury that resulted in benefits, it didn't have to actually cause a disability finding. On statutory language or case law?
Again, Mr. Schnurr says what I'm asking the court to do is to overrule Kohlhaas. No. Kohlhaas stands for the proposition that res judicata applies and that proximate cause is required on a review reopening. What he's proposing would overturn Kohlhaas and not require that. Well, it doesn't say that. I'm sorry. It does say that if you have proven an injury that arose out of it in the course of employment and that the same resulted in medical treatment, but other things were not ripe yet, maybe they weren't done healing, maybe they were still treating, maybe they hadn't reached maximum medical improvement, hadn't been rated. In that situation, that issue was not ripe yet, so they were able to come back and file review reopening. Here is completely different. What's happening here is an attempt by Ms. Green to resurrect her own claims, her old claim, by seeking additional treatment on her own after an additional award when it has been conclusively established that her condition resolved without any permanent disability. She sustained no temporary disability, and she's not entitled to anything other than what she has already been paid. Again, the agency, in its appeal decision, followed res judicata principles. It followed review reopening rules precisely. It recognized the importance of that. We shouldn't have to be here today on this issue. This case was over with the judicial review decision. I'm sorry, I'm trying to make sense of my scribbled notes, which I often do during rebuttal. So, a final question. I'm not supposed to ask you questions, but I would pose this. How is Ms. Green supposed to succeed on a review reopening petition without relitigating the issue of whether her injury approximately caused disability? That's not what review reopening is for. That's been decided. Everything after her own treatment, new opinions, none of that is relevant to the motion for summary judgment. That's all I have. Thank you.
Of Green versus North Central Iowa Regional Solid Waste Authority is hereby submitted. Next case, we'll have a switch of attorneys. Will be Lincoln Savings Bank versus Emmert.